Hello, it's Shannon Gunn Emery here again with the last segment of our newest version of how to run and hopefully win your IRS, the segment where we talk about how to prepare your written and your oral arguments. I'm going to start with the written arguments. Now, at the outset, I want to remind you that when you set your matter down for an appeal, you'll be given two options. You can have a written appeal or an oral appeal. Try either one. They're both $150 each. Why would anybody go with a written appeal? With oral, you get to send in the written submissions you would have done on a written appeal, but then you also get a half-hour timed hearing in front of a SafeRoads adjudicator. So always opt for oral. When you're preparing your written submissions, you can get a little bit nervous. You might be wondering, what should I put in there? What should I not put in there? I'm going to walk you through it, literally from top to bottom. Top right, the date. That's the date when I'm sending them in. Reline. I put my client's name, the contravention number, the date of the occurrence, the date of birth, and the occurrence time. And guess what? This is all the information you are going to need to log into the SafeRoads portal, but summed up in a very handy spot in one place. So the day of the hearing, I can just go to my Reline and I know all the information I need to log in quickly is right there. Right underneath that, I put in a sentence that says something like, the notice of administrative penalty was issued by Constable, whatever the name was, on whatever date it was, on the basis of impaired operation of a motor vehicle and 80 plus, or solely on the basis of failing or refusing, whatever the case may be. But it's important to note what the basis of the NAP was or were, if there is more than one basis, because those are the sections of the SafeRoads Alberta regulation that you're going to have to address specifically. Section 4E deals with impaired charges. Section 4F deals with 80 plus. That's when you failed the screening device test. Section 4I is the section relating to failing or refusing to provide a proper breath sample. So under the grounds section, which is right after the sentence about the NAP was issued by Constable so-and-so on that date, I will note section, for example, 4E4 or 4F3 or whatever it is, along with any arguments which touch on duty of fairness. Next section that I look at is the evidence section. I will often say, my client swears or affirms the following is true. Now, swearing and affirming are not the same thing in one respect. The way they are similar is that both bind a person's conscience. But when someone swears to tell the truth, that means they are promising to God to tell the truth. When they are affirming, they are leaving God out of it and just promising to tell the truth. The adjudicator will not give more weight to one or the other, so it's really up to you to look in your heart, think about what are your beliefs, and if you believe in God, I encourage you to swear. Not a bad thing to have God on your side in these kinds of appeals. On the other hand, if you don't believe in God, just affirm. It's fine. If you're self-representing, just know, though, that you might be at a bit of a disadvantage. According to the legislation, the evidence from the police officers is deemed to have been under oath, but yours isn't. And the SafeRoads adjudicator cannot administer an oath or an affirmation. So I would suggest you give it to yourself. Yes, self-administer the oath. Just start out by saying, I solemnly affirm that the evidence that I put in my written submissions and any evidence that I'm about to give today is the truth, the whole truth, and nothing but the truth. Or, if you'd like to swear, you can say, I solemnly swear that the evidence that I put in my written submissions and any evidence that I'm about to give today is the truth, the whole truth, and nothing but the truth, so help me God. And then I would say, That's under oath. That's as good as you're going to get if you're self-administering. Now, when I'm doing this on behalf of my clients, that's exactly what I ask them. Did you read over your written submissions? I say it on the record. They say, of course, yes. And then I launch into, do you solemnly swear or do you solemnly affirm that, da-da-da-da-da. And away we go. So I'm not into affidavit evidence. I like to put it that way also because if you only go with affidavit evidence and your client gives evidence during the hearing, then what about the evidence during the hearing? That wasn't sworn. This way, everything's sworn. Okay, so under the grounds, I have an evidence section, and this is where you'll put in everything that you remember from that day. Also remember that as part of your appeal, you can upload supporting documentation and supporting records, and those can include emails, screenshots, maps, receipts, texts, prescriptions, witness statements, audio and video recordings, and those can be from your phone, the doorbell, the dash cam, the garage door, pretty much anything you want to rely on, we can put up there. And I must say, I really do like that about the SafeRoads regime. If you do upload other documents like that, touch on them in the evidence section, like as you're writing about, I turned right at this corner and I know that it was about 2.3 kilometers from the bar that I left, and I have uploaded a map from Google that shows the exact distance. Or, I had this many drinks to drink while I was at the bar, and I have uploaded the receipt which outlines those drinks. Make your evidence section as complete as possible. Where you're not sure, say so. If you've only got a 60% recollection or 30% sure of something, say that. If you're only 30% sure, though, I don't think I'd even mention it at all. If you're 100% sure, say, I am absolutely certain that this happened, etc. Put in the evidence of your other witnesses. Yes, you can call other witnesses. Was there a passenger in the vehicle? Did you call your mother to pick you up and you were waiting for her to get there when the police officers arrived and you explained that you weren't planning on driving anywhere? You were waiting for your mother to get there and she can back that up, and you both have screenshots of all those calls and text messages. Upload all of that and summarize your mother's evidence. You can put in all of that in the evidence section. Next section would be arguments. They can be based on duty of fairness. They are usually on enumerated grounds. Add the cases in support, and away you go. Last section, conclusion. Based on all the arguments noted above, the NAP should be cancelled. Do not argue hardship. Don't try to argue sympathy. That won't go anywhere. Don't ask for a reduction in the penalty. Don't ask for a special restricted license that will allow you to drive only during working hours. That isn't a thing. I wish it were, but it's not. The adjudicator cannot modify the penalty. They can't make the suspension shorter. They can't make it so that you can forego the ignition interlock. They can't make the fine lower. All they can do is cancel the penalty or uphold the penalty. Although, one little caveat, if you were given a NAP for a second or a third offense and it really was a first offense, they can drop that down, but you are going to have to do some convincing to let them know that it really was a first offense and not a second or a third. Moving on to oral argument. We already talked about swearing or affirming your evidence. So the day of the hearing, when you're getting ready, you should have already downloaded the WebEx app by Cisco. That's WEB capital EX, because putting capital letters in the middle of a word is a really exciting trend right now. That WebEx app from Cisco, CISCO, should be downloaded ahead of time. Log into the portal. If you don't remember how to do it, go back to that Legalize episode. And then you wait. Now, most people will log in about 5 to 10 minutes ahead of time because they don't want to be late, but I'm going to let you know, most adjudicators will open the hearing literally the minute that it's supposed to be heard. So if your appeal is at 2:00, it's not, 1:58, it's not 1:59, it's 2:00 on the dot that boom, the whole thing opens and everything starts. So don't worry that you're in the wrong place if you were logging in and somehow it's not working. Don't forget too, if the join the meeting room button isn't working for you and the audio and video recordings aren't working for whatever reason, you can use that phone number to log in. And that's okay, because at the end of the day, the only thing that's recorded is the audio recordings. That is also why it's really important that if you want to show the adjudicator anything, take a video of it or take a picture of it and upload it ahead of time. Because even though we'll be able to see everything you're doing on video during the hearing, we have to keep in mind what might happen if you lose. There we want a clean record. If you do make a gesture or you have to show something on the video, hopefully you don't because you heard this podcast and you thought about that ahead of time. But if you do, describe what you're doing. I'm making a motion with my right hand balled up into a fist and making a shoving motion like in front of my face towards my chin, and that's how the officer hit me. At least it is clear on the record what you are trying to show on video. Don't forget the hearing is timed. And don't forget the time starts after the adjudicator's spiel. They're going to go and tell you that they are an impartial adjudicator and their role is to give you a full and fair review, and they have to consider all the evidence, and the officer's evidence is deemed under oath, blah, 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 blah. And then they will tell you that it's your turn. That's when the 30 minutes starts, not before. So don't worry, don't get antsy when they're giving you all that information, because it's okay. They're going to give you time. I recommend having your phone out or another device out that has a timer on it. Set it for 30 minutes, and as soon as they say it's your time, go. Because they may or may not give you any extra time. Sometimes they're lovely, but I once had one who would not give me that time. So just be aware. One good thing about the oral hearing, you can bring up arguments and cases that are not in your written submissions. That's the lovely thing about an oral hearing. So keep in mind, your written submissions are due 2 clear days before the hearing. Also keep in mind, the police evidence is due 4 clear days before the hearing. So you don't want to have filed your written submissions earlier than 4 clear days, because then the officers could go into the portal, see what you wrote, fix the issue, upload their extra documents, and now you lose. Don't do that. Wait till the 4 days is up, but don't wait until the 2 clear days is up, because then the boxes that allow you to upload documents will be grayed out and you won't be able to upload anything. So 3 days is good, 2 days is good, and it's 2 days at midnight. So say, for example, your appeal is scheduled for Monday at 9 a.m. Sunday is one day, Saturday is another day, Friday at midnight is your deadline if your hearing is on Monday at any time. Got it? Good. When I go through my oral submissions, I will often ask my client to interrupt if I say anything wrong about their evidence or anything that they've said, because they were there and I wasn't. And I also want to make sure that the adjudicator knows I'm trying to make sure this is as accurate as possible. So I encourage my clients, interrupt me, just say, excuse me, sorry, I don't think that was quite right. Or if I could just add something. I love it when the clients add something. And frankly, I think the adjudicators do too. I do think that some of them really like to hear from our clients. So jump in, add whatever you want to say, use your written submissions as a guide to make sure that you're staying on target and you're hitting all the arguments that you need to hit. You can also bring up any new cases that came out between the time that you had to file and the day of the hearing, because New cases are coming out all the time. And just recently, that happened. Like July 31st, 2024 was a golden day for judicial reviews in Alberta. A whole bunch came out that day, mainly from Justice Spoken For, maybe all from Justice Spoken For, if I'm remembering correctly. It was her homework day to get them out, and she banged them out like crazy. Great day. Kolner came out, Singh came out. I think DeVenis also came out that day. And so I was able to use those in a hearing the day after. Keep that in mind. One thing my clients often ask me is, am I going to be asked questions? And you might. The adjudicator might ask you questions, but it's nothing like TV. There is no cross-examination allowed of anybody. I have sometimes come close to cross-examining the adjudicator, but the adjudicators have never, to give them their due, even come close to cross-examining my clients. I'm very objecty. Doesn't take much before I'm on my feet saying, I object to something. But I've never had to object so far to any adjudicator questions. Again, kudos to the adjudicators for being careful in their questions. Although the adjudicator may give you a little bit of extra time, they may not, you never know, we'll see. Don't expect a decision that day, because I can almost guarantee you won't get one. I think in all the cases that we've done, we had that happen once, and that was rare. Normally, you get the decision on the 30th day from the date that the NAP was issued. Every now and then, an adjudicator will send it out early. I have never had any of them send it out late. Again, kudos to them, because the BC system, wow, is that really bad compared to ours? They apparently take months and months and sometimes almost never send out their decision. There are lots of cases on how tardy they are in sending out their decisions. Not us. Speedy, speedy, speedy. Although there is that adage that the wheels of justice move best when they move slowly. This new system does have some advantages. You can upload nearly anything. You don't have to make your submissions pretty, and the adjudicators will listen to what you have to say for the most part. When you do get the decision, you have 30 days within which to seek judicial review. If you won, I wouldn't do that. You won. Hooray! If you won, what you do want to do is get those seizure and impound fees back. So there is going to be an email that you're going to have to send to your respective police agency. There's a lot of red tape involved, but you do get it back. And it's worth the red tape and the effort, considering that it's normally between $1,800 and $3,000 to get that vehicle out of impound. Once you've won, that's not quite the end of it. You want to make sure that you get that money back. If you won, there's going to be a credit for you at the registry's office, so you don't have to pay anything to get your license back. You don't have to redo any tests. You certainly don't have to go for ignition interlock. There is no suspension, no fine to pay. It's as if this never happened. No entry on your record. This has just been a little bump on your road of life, and now you're back on track. If, on the other hand, you didn't win, like I said, you have 30 days within which to seek judicial review. Although I think, to be fair, in some cases, some people could pretty well self-represent on the IRS, especially if you have all this coaching that you got free from Gun Law Group. Lucky you, lucky everybody, because I'm not putting any passwords on anything either. You might be able to do that. You will never, in a million years, be able to do the judicial review on your own. Lawyers already are puzzled, baffled, and it is not a fun situation. Just recently, the Court of King's Bench changed the naming conventions again. There is a new way of filing electronically, but once you've filed, that's not the end of it. No, once you get the file document back, you have to send it to another electronic, portal, regime, group, who knows, so that the judge gets to see it. I thought that was the role of the clerks, but apparently now it's our role. And who are the parties? It depends. Do you have a charter challenge going? It's just a nightmare. So don't do that on your own. That's the best advice I can give you. And if you do this on your own, the IRS part on your own, just remember, you didn't hear any of this from me. You did not get legal advice from me. You can't come back and sue me because you didn't win, because I said this was an argument and you lost. If you want to make a really good case against me, you have to hire me first. Good luck with everything. And at least now you know how we try to work on your behalf. See you next time.